Díomh go léir go dtí an Scoils Lí Sutherland Hanocht Arnach Goidsin. Hello everyone. You're very welcome to the UCD Sutherland School of Law this evening. My name is Imelda Maher and I'm the Dean of the Law School. We're here tonight to honour the memory of our colleague Paul Anthony McDermott. It is roughly a year since Paul passed away, and we are absolutely delighted that on this occasion we get a chance to mark his latest book, which he has co-authored with the Honourable Mr. Justice Peter Charleton, who is with us this evening. Paul was UCD to his fingertips. He was an undergraduate here and he graduated with a first-class honours degree. He proceeded to do an LLM at Gonville and Keys in Cambridge, where he also received a first-class honours, and during the year also won the World Debating Championships. He returned to Ireland, was at the King's Inns, won the Irish Times debating, and luckily for us, he also joined the faculty in UCD Law School. He started out teaching tort, and he also undertook a PhD under the supervision of now Emeritus Professor Paul O'Connor. It was on res judicata and formed the subject of one of his books. He published a book on prison law. He published a book on contract law, second edition of which appeared about 2 years ago, where his co-author was our colleague and Paul's brother, James McDermott. And his most recent book is Criminal Law and Evidence, and that is the book that we are launching here this evening. The law school had hoped to honour Paul earlier this year, but due to COVID, we were unable to do so. We were honoured when we were contacted by Judge Charlton and asked, could we launch the book here in the law school? Given the law school was such an intellectual home for Paul, we were particularly pleased to do so. This event this evening is also designed to be educational, which is what I think Paul would have liked. Our students have had a really tough semester, having to learn online, learn remotely, a challenge for them and indeed for my colleagues. So we are particularly pleased to have a member of the Supreme Court with us today who will be able to talk to us about criminal law and evidence. The evening is divided into two parts. We are also very pleased to have with us this evening Ms. Annick Hedderman. Annick will speak, and then I will have a conversation with Judge Charlton. Annick Hedderman is a solicitor, a graduate of UCD, and Annick also completed an LLM here in the law school some years ago. In fact, she briefly worked as a member of our admin team, and as a result is well known to many of my colleagues. We're really honoured that you have come here this evening, Annick. Thank you.
In Paul's preface to the first edition of his contract law book, which he wrote in 2001, early on in his career, he cites John Irving's novel, The Cider House Rules, which notes that the primary ambition of one of its main characters, the orphaned Homer Wells, was to be of use. This, I believe, was Paul's objective in life, to be of use. To be of use to students by setting out the various legal rules and principles and their exceptions in a clear and concise manner, while making them simultaneously interesting. To be of use to practitioners by consolidating and commenting on Irish jurisprudence and comparing it with other jurisdictions. To be of use to those with a general interest in law and reform by explaining some of the anomalies and gaps in a particular area of law. And to be of use by colouring a subject matter that can be serious at the best of times with humour in his weekly column in the Sunday Times. Paul had a unique and rare ability in a discipline that is full of twists and turns to extract and make accessible and to bridge the gap between it and its end user, be it student, client, colleague or reader. He had a remarkable talent to distill and make simple something that was often quite complex by applying first principles. From my own experience as a practitioner, this is one of the main skills that we need as lawyers, the capacity to simplify as opposed to complicate. Paul was a master at this. He had written almost 10 chapters of the second edition of Criminal Law and Evidence before he became ill. But I know that he had discussed the form and shape of it extensively with his good friend and colleague Peter, who had been looking forward to spending more time with him in their rewriting of their book. I do recall Peter saying to me that he felt Paul driving him on like a horse in the months that followed his death. And with the dedication and skill from Ciara and Stephen, they have successfully completed this enormous task, which will be a great resource to practitioners and students alike. Paul once described the handing over of a manuscript to a publisher's felt like bidding goodbye to a difficult relative who has invited themselves into your house and stayed longer than anyone anticipated. Relief that they have finally left is mingled with trepidation as to when they might come knocking again. I have no doubt in my mind that he would have been delighted to know that such a comprehensive reworking of the first edition has now been published. And on behalf of myself and our two little boys, Harry and Andrew, his mother Margaret and brother James, we are so very grateful to you all. I had the privilege of walking alongside and observing a man who excelled in their field and who wore it very lightly and had a total passion for what he did. He had a wonderful curiosity which he carried with him throughout his life. He adored books and loved to be surrounded by them. And I think that he never felt alone as long as he had one in his pocket or by his bedside. He appreciated how much they could enrich one's imagination and knowledge. I will leave you with the quote from an Irish astronomer, Agnes Mary Clerk. Myself and Paul had stumbled across an exhibition about her at her birthplace in Skibbereen, County Cork in the summer of 2017. I think that it had a tremendous impact on Paul. He was fascinated by this lady who was born in a small Irish town and ended up writing a number of leading seminal texts in astronomy. I think that her idea of what a book should be resonated with him. In her text, The System of Stars, she explains the reason for writing the book was to bring it within the reach of many. The general public has an indefeasible right of access to its lofty holes and impediments, since the natural tendency of all sciences is to become specialised. We hope that Charleton, McDermott, Herlihy and Burns Criminal Law and Evidence serves to be of use to all in whatever way required. Thank you.
Thank you, Annick. Every year, the College of Social Sciences and Law asks the students for nominations for teaching awards. Paul had taught with us until November last year, and his students nominated him for this award. This is absolutely no surprise because Paul was an absolutely inspirational teacher. In fact, he was inspirational in the classroom. He taught towards the end of his career, he was teaching civil procedure and criminal procedure. Now, I don't think anybody will contradict me if I say that when it comes to the law curriculum, procedure is not usually a subject that students rush to take. It's seen as relatively technical and dry. But it has to be said, in UCD, that was not the case. Paul's classes were students simply flocked to them. And what was particularly interesting, and I only discovered it when I became dean, was that even non-law students wanted to come and study civil procedure and criminal procedure. And I think that is a real testament to the quality of his teaching. And so that's kind of the public part of his teaching. But what we also discovered, and which I was aware of also when he was a colleague, is that after he died, the number of messages we got in the law school through Twitter, email, Facebook, from current students, from alumni, all noting the support, the inspiration that he gave them, not just within the lecture theatre, but also when he would meet them during his office hours. He was available to the students to give them guidance, to give them advice, to answer their queries. And there's many a career that is better than it would otherwise have been, thanks to Paul's devotion and dedication to his students. So as I say, we are really pleased that even though he didn't get to finish out his semester last year, that the students still wanted to nominate him. And they also talked about him at their graduation last September. So I don't think I can give you this, Annick, because of COVID, but I just want to show you, and we'll give it to you afterwards, is the certificate that honours Paul's teaching.
Thank you. Thank you.
So I'd like now to turn to the other guest we have with us this evening, and that is the Honourable Justice Peter Charleton. Peter. You are a member of the Supreme Court, having previously been on the High Court. You've had an eminent career at the bar prior to joining the bench, but also are an author of many books, it has to be said. And in particular, we're here this evening to honour the Charleton and McDermott second edition of Criminal Law and Evidence. Now, we're here to talk about the book, but it would be remiss of us not first of all to reflect a bit on you must have known Paul extremely well over the years. Maybe you'd like to tell me about how you first met Paul.
Well, for a start, there's a big age gap. Like, Paul would have been 20 years younger than me. And so you're going to see a slideshow later on from 1999, photographs that I took. Ends with a beautiful one that Annick took very recently, just earlier in the year. But I used to do a lot of work with Tom O'Connell and Eamon Leahy, who are part of that slideshow. You see them together in the prosecution room in Green Street. Well, one particular day, Tom turned up with his devil, who was a young, callow youth. It was Paul Anthony McDermott, to whom I didn't pay the slightest bit of attention, I'd have to say. But then a crisis happened in the case. I can't tell you what it was, nor can I tell you about the rumour that flew around the law library immediately the crisis happened, because rumours do fly around the law library. Perhaps it's WhatsApps that fly around the law library nowadays. But I suddenly realised we were speaking in a very uncomplimentary way about a number of people. And then I realised, oh, here's a guy who's about 25 who hasn't got a clue how to keep his mouth shut. And I just turned to him and I said, so you know we're not going to talk about this outside this room. And he said to me, no, I realise that. And for some reason, I instinctively just trusted the guy. And I was at the time writing a couple of things. One of the things that was obsessing me was plea bargaining. And this is how I kind of got to know Paul's sense of humour, because at that time, the state authorities had, for some bizarre reason, rung me up or written to me and said, oh, by the way, we don't want you in such and such a case because we don't think you're a constitutional specialist. And I was absolutely furious. And I mentioned this to Paul. And I said, look, maybe you'd like to co-author this article with me. And I'd had some of it written. And of course, Paul went and he got loads of American authorities, etc. We beefed the thing up and it was very good. Except the title had changed from plea bargaining to constitutional aspects of plea bargaining to prove that both he and I were constitutional experts. Not that anyone paid any attention. So, yeah.
And how did you come to write them? Because the first edition of the book came out in 1999. How did you come together to collaborate on such a big project?
Well, we'd done a few articles, and Paul had indeed added constitutional monikers to a few more of them, I suppose, to make the point that was already made. But I had a casebook, and the casebook was linked by various passages explaining the principles of criminal law. And I said, look, Paul, we could actually turn this maybe into a proper criminal law textbook. And he said, yes, we could. We divided it up. Marguerite Bulger took on certain parts of it at the time. She then moved on to specialise, as you know, in employment law. And he worked at a chapter, I worked at a chapter. That particular book was characterised by very long quotes, because what we thought at the time was, look, if someone's going on circuit, and both of us were jobbing barristers, if a guy goes on circuit or a girl goes on circuit, what they need is a thing they can take out of their bag and they can say, here's the full quote, here's the full section. But when we came to write the second edition, which is 21 years later, Paul's idea, and he was right, was, look, everything's on the internet now. What we need to do more is analyse the principle, give comparative authorities, give all, in the footnotes, everything that could possibly be of relevance to a point or a principle. So that's how it evolved, yeah.
And did you comment on, you said you divvied up the chapters. Did you comment on each other's chapters then, or was there any need to, or were you?
No, things, Imelda, you know yourself, I mean, they don't come out perfect. So, I mean, even in this, when Paul was writing, I was changing. When I was writing, Paul was changing. Yeah. And, I think probably the idea was Paul had a very strong practical streak, but we felt the need in the second edition to do more in terms of really explaining how criminal law works. And so there wasn't a tension between us, but there was more, a need for the practitioner or practical side of thing, the principle side of thing, the theory side of thing, to come together. And I think we managed to do that, well, pretty well. At least I certainly hope so.
And if I may say, I think that's the sort of thing you can achieve with a co-author when you have a long-standing working relationship together, that you can trust each other enough to be critical of each other's work, to make it better, to polish it. Well,
Paul never minded. I never minded either, because I knew whatever he did was an improvement. There's no doubt. So, and besides that, I mean, over the years, I wrote a book about the nature of evil, which, to put it mildly, was not a big commercial success. But I mean, the person that I turned to read the chapters for me, give me feedback and advice, was Paul. So, I mean, if he felt it was readable, if he felt I was actually managing to make a point in a coherent way, I felt, okay, so I'm getting something across.
So we're talking very much about the serious side of Paul, if you wish. But of course, we all know he had an excellent sense of humour. I know you can share some of that with us, perhaps.
Well, I mean, the thing about having a go at whoever the state authorities were who thought that neither he nor I were capable of dealing with constitutional law is one, and it's pretty obvious. But I mean, it just came up from time to time, and Annick will tell you, just this odd, quirky sense of humour keeps, bubbling to the surface. Like, he was in the Disclosures Tribunal, and I sent him the report by email, and I said, here's the report. The newspapers are calling this the explosive Charleton report, or something like that. Yours, Peter. And back comes an email a day later. Dear Peter, I have stored your explosive report beside some cans of petrol in the basement of my house, but so far nothing has happened.
Brilliant.
Don't take things too seriously, I think is the subtext. Yeah.
Excellent. And then it's interesting that you're talking about, on a very functional level almost, how between the first and second editions the internet had emerged. So the need, as you say, for quotes and statutes is diminished as a result.
Yeah.
What other, substantively then, if we look at the time lag of 20 years, what do you think have been the major changes that you've seen in Irish criminal law between the first and second editions?
Well, there's a tendency in this country to, if there's a problem, look to procedure, as if procedure will actually solve everything. I mean, it may reasonably perhaps be argued that procedure doesn't necessarily change everything. Just because you, for instance, listen to someone doesn't mean that you can't ignore them. Whereas I think we feel if someone is listened to, and it's a good thing to listen to people, that automatically solves a problem. And in some ways, therefore, it could be said, I don't know, could be argued that we're substituting essentially sense for procedure. Now, one of the things that was a huge thing, and it's still in this book, and there's maybe still 20 or 30 pages about it, was the whole notion that because there was a mistake by a police officer, you could stop a murder trial, rule out a whole load of evidence, And that indeed was the tip of the iceberg, because those are the cases that got to court. And then there was the cases below the waterline that never got to court, that got to the DPP's office or didn't even get that far because warrants were wrong, because somebody had made a mistake. Changing that has obviously had two effects. First of all, there's access to justice. And that was a decision of the Supreme Court about 5 years ago, CC. But in addition to that, it meant that substantive criminal law was never argued. So why argue about substantive criminal law in its nature when instead you turn to getting the evidence out and therefore getting the accused off, as opposed to saying, look, there's a genuine defence, or the defence happens because of this concept. And the change in that regard, I think, has been enormous, because if you look at even the defence section, there's been several in the last 2 or 3 or 4 years, cases where people have actually argued the substance of criminal law as opposed to going down the narrow alleyway and perhaps sterile alleyway of procedure. That certainly has been one big change. Another big change has been the fact, and this is not a book about sentencing, but we do mention it, the fact that we've moved from sentencing being effectively in pectore, or as Lord Denning said, in the breast of the judge, to having actual sentencing guidelines in several cases and also in several manuals, so that people, again, who are seeking access as victims because of like sexual violence or something like that, they know there are categories, and the DPP now has to refer to the categories in saying, look, I'm not looking for a 10-year sentence, but I'm saying this is in the category of between 5 and 7, or the category between 7 and 14, according to the decided case or according to the manuals which have been circulating. So that's been an enormous change, and I think very, very definitely a change for the better for everybody.
Another issue that I know was near and dear to Paul's heart, that is discussed in the book, is this question of codification.
Okay, well, codification, I mean, there has been a committee, and you know, if you take the size of this book, like it's about 1,500 pages, and you say, okay, we codify the whole of that, in other words, you write it down in a statute, the laws become very complex. But really, the two of us discussing that, we're saying, okay, take this act, which says the mental element is knowledge or intention or recklessness or should know or ought to have known. I mean, all of those things are different, but if you actually look at them, none of them are defined. Whereas if you go to what we put into the second edition and into the first edition itself, which is code options from various countries like Australia or the American Law Institute Model Penal Code, and you go to something like intention, where the United Kingdom House of Lords would have spent case after case after case discussing intention as to whether, you know, a brick thrown from a bridge onto a car which results in a death was an intentional death or not, or whether someone, believe it or not, who shoots somebody's head off with a gun actually intended to kill that person. Whereas if you look at the code, it's actually there. Intention means it's your purpose, simple concept, it can be easily written down. And if it's a case of what they call oblique intention, as where a train is going from Belfast to Dublin and you mean to derail the train, your intention may not be to kill the people on the train, but by derailing it, if you know that in the circumstances, the likely result of your maneuver, your protest, or whatever it is, your criminal act, is that people will die, then intention doesn't happen automatically, but it can be inferred. And that's something that's not too easily grasped and has had so many cases about it, but which is very simply and very easily set out in some of the examples that we have in the book.
Thank you. It's really interesting. So we've talked about, you know, what has changed in the last 20 years. What do you think are the key challenges in the criminal law world at the moment?
I think a key challenge in all litigation is focus, because as compared to even when Paul started practice, which would have been a good 15 years after me, the briefs were that size. Now they're that size, or they come in boxes. And you have all kinds of elements of law impacting on even a simple enough problem. And the difficulty is to narrow things down so that you're actually dealing with the point that decides the case. That's difficult. In criminal law, you wouldn't have expected that to happen, but it does happen. like people being detained and cross-examined for a number of days. Is that right? Is that something to be looked at? Is that something which can be improved, whereby people are encouraged to focus on things? In England, since the Wolf reforms in civil law, you have that. In Ireland, we're very strongly moving towards that now, but I'm not sure we've moved enough. But in criminal law, it seems the diffusion has begun to break in, where cases actually last weeks or months. And I'm not sure they need to, and perhaps that's something to be looked at. But that is a definite challenge. It's a challenge, certainly, for those who are the victims of crime, particularly.
And is that excess, or not excess, but that greater quantity of information and paperwork, is that partly a product of technology again? The availability, it's easy enough to print out things or present them, or is it for other reasons?
Well, I think, the law school in UCD can claim credit here now, because I think you've trained people so well, and I'm sure Trinity and Galway and Cork, etc., have trained people so well that we have working in the courts now fantastic legal researchers. I have 2 working for me now, and then last year I had the 2 who are mentioned in the foreword who helped with this book. But they can find me cases from Australia, New Zealand, America, all the rest of it. And so you have a plethora of authorities that you can bring to focus on any one thing. Now, as Annick said vis-a-vis Paul about being of use, you can't remember this stuff. I defy anybody to remember it. You need to be a chess champion, frankly, to get all this stuff into your head. What you have to actually do is to distill it down into a principle and say, how does this principle work? And then all the case law, etc., fits in. But certainly you can, I suppose, argue things for days on the basis of conflicting and massive authorities from all over the world. Yeah.
If I may, I'm reminded of when I was an undergraduate and there would be one copy of the unreported judgment that everyone had to read for class, held by the Miss Semple behind the desk in the law library, and you'd get your half an hour. It would be allocated out. Like, the world has transformed. It's now about managing the amount of knowledge that you're having to contend with. I think that's very true.
Yeah, it is. It is.
So what about the future then? Like, if future, you can't foretell the future, but what do you think may be the challenges then in 10 years' time, even in 20 years' time, that will exercise the minds of people like yourself and like Paul and those who will follow in your footsteps?
I think you can't do everything. I think what you have to do is you have to do what you can. And the job of a textbook writer, the job of an academic, that is why those of us who are in practice respect academics so much, is to engage in a distillation process whereby disparate pieces of information come together and is put into a coherent whole. The law is not going to get any easier, it's not going to get any simpler, but still, underlying the law is what drives the law. Why is the law there? And if you can understand that and how the principle works, well then our job is to put that in a form which makes it accessible, which makes it usable, because without doing that, without doing the work you do and the work that Paul and I did on this, mistakes will happen, and they shouldn't happen. That's not what the system deserves.
It's very much this idea that it's necessary to demystify the law.
Yeah, but the law is a mystery, but I think when you have teachers like Paul and yourself, the law suddenly becomes accessible as if a door is opened up. And I don't know about your students nowadays, but we used to collect books, and a text was like a very valuable thing because there wasn't very many of them at the time. But a text is like an entry which brings you into a wonderful club where there are so many resources which you can use. A book is the same. A book is like, as Annick said, a book is like meeting a person. You're not alone. And even a dry as ditch water textbook, such as the one that I have on my lap, necessarily, underneath it all, I think you'll find there's the personalities there. There's me, there's Paul, there's Ciara, there's Stephen. Yeah, and I hope to some extent, when you write something down, and nowadays it's all clickety-clack typing, you're actually hoping to connect with somebody. You actually have your end user in mind. it's like a conversation across the ages or across time or across the world, whereby you hope that something that you think will go into somebody else's mind. They don't have to accept it, but at least it may be it may stimulate thought from them, and that's you can hope for that, and I think legitimately.
And I think it's both a process of, on the one hand, demystifying the law while simultaneously showing how complex it is.
Yes.
And that balance is actually very difficult to achieve, and which this book has achieved. I'm not a criminal lawyer, and I could still make sense of it as I read it. So, but it is. I think that's the real challenge, and it also, so that's one dimension you're trying to manage when you write a text such as this. But there's also the dimension which you've referred to, and which Paul did so brilliantly, is straddling between the world of the practitioner and the world of the academic.
And there's another world as well, of course, in Paul. And that was, you'll see in the slideshow now, it was funny because I used to bring my camera everywhere. It was my Leica M6, which I still have, black and white, I don't know. And Paul and I were invited, I thought it was to Gay Byrne, I think we were on Gay Byrne as well, the radio show, but we were definitely on Shane Ross's show on Today FM. And I remember sitting there with him in the studio and the big microphones. And this was the first time he'd ever been there, anywhere, to do with the media. And I saw kind of a twinkle in his eye. And it didn't strike me at the time, but it was funny how it developed. He didn't want public attention. He didn't lap up public attention. He didn't want to be noticed. I mean, I think I'm right about that, Annick. Yeah. But I think he felt a certain duty. He was the one with the knowledge. He was the person who could unlock the door for people and tell them what things was going on. But he also had an enormous sense of things, how things should be, how the law should actually work. And he felt it his duty to go out there and explain it. And it was after that he started regularly to appear on the television, on the radio. And it's actually a presence, I think, that's been missed over the course of the last year. And it's funny how no young lawyer has come along really to take his place.
Not easily done.
No, not easily done, I agree. But there surely are people out there with that combination of both knowledge and sense, and also the sense of public duty, the duty of lawyers to explain the law to the public.
To make it apparent, because it's not obvious.
No, it's
and,
not
and that distinction again can be lost sometimes. That's very true. And finally, I know we have many current students and also recent alumni who are tuning in for this. And I wonder, would there be any advice? As I said, they've had a hard trimester. Our current students are just finishing up all their assessments and getting, the final date is the 23rd of December, I think, the last exam. Is there any advice or guidance that you, as Supreme Court Judge, who's honouring us here this evening, would like to give our students?
Well,
or reflections?
I'm honoured to be here, Imelda, with you and with Annick. Look, I don't know if in the age where it's perhaps believed that the only world is the material world, that we can say that every day is a gift from God. And certainly days happen where you certainly don't believe that the day is a gift from God. But I think the whole point of every day is the sun comes up and you can actually get something done during that day. You know, I read stories about people who were not very good at football, but who worked intensely hard at it by kicking a ball up against a wall at a ring that's marked out. James McDermott, who's here, would tell us more about that. But through hard work, you can turn yourself into something. Okay, difficulties will come along in life. They always will. Perhaps some part of every day is not going to be great, but some part of every day is going to be good as well. And before the sun goes down, if you can try and make some use of it, to try and get something done, it's not a question of giving people advice, but that gift of that day is there, and to try and make use of it and to try and, push things on a little bit. Let's not get like, dead poets society and the teacher tells his students, make your lives extraordinary, because so many lives are extraordinary which are hidden. So many lives are heroic, which are hidden, which are out of sight. And challenges come along and we try and deal with them. And in the same way, with every day, we try and deal with the day that's in it, and we try and get a bit of work done during that day.
So, yes, one foot in front of the other, I often think. Keep going with the work.
Exactly. Yeah.
And actually, your moment, this moment, even where people have quite a public persona, as indeed Paul had, there are often moments of quiet kindness that we became very aware of after he had died. And that quiet kindness can continue even where someone has quite a public side to them as well.
Well, maybe those are the things that, actually last, giving somebody a handout when you can. And certainly there's so many people in my life who've done that. And I don't think that it's wasted, because I think what goes around comes around. Like if you do something for somebody else or somebody else's kid, someone's going to come along and do something for one of yours. And, it's like the setting up of Alcoholics Anonymous, where the guy had this vision of all of these people who had this problem interconnecting with one another all the way around the world and helping each other. I mean, that's a thing that happens indeed every day, and it happens in a very quiet way. And it's something we're all obligated to do, to try and give other people a handout if we can.
Thank you. Thank you, Annick. I think we've reached a natural pause in the discussion.
Yeah.
So I'll bring proceedings to a close. I'd very much like to thank you, Peter, for coming, and Annick, really thank you for your beautiful words. Very powerful and really wonderful that we hear them here in the building as well. That really matters to us. I want to thank Una Kelly, my colleague, who has worked tirelessly. This is an event that we had arranged, we had to postpone, we arranged, we had to postpone, given the times that are in it. But Una was not going to give up, so I'm really thankful to Una for that. And I really want to thank all of you who have joined us this evening. If times had been different and we were able to have an event here, those numbers who could attend would actually have been fairly small. But I understand there's a lot of people who've signed in this evening. And again, it's a mark of respect and regard that people hold Paul in that has happened. So thank you for doing that. And it matters again to the school that has happened. I want to thank James McDermott, Paul's brother, who I've been liaising with around this evening's event as well. And James, we're very much thinking of your mother Margaret today. In fact, I've been thinking about her all week. And also, of course, we're thinking about Harry and Andrew that Annick has mentioned. So all I have left to say is Slán agus banach liv go léir, agus solas an bhlochas dá anam. Thank you.